Welcome everybody to this fantastic Investor-State Dispute Settlement Roundtable. For those who don't know me, I'm Laura Skillen, the Executive Director of IMI, and we also have Jess here from CIMI, our friends as well. Now, before I introduce Wolf, who will be the moderator for today's event, a little housekeeping. For those of you who haven't used Zoom webinar before, there's a special Q&A function. So if you do have any questions for the panelists, please pop them into the Q&A section so that we'll be able to address some of those. And you'll find it at the bottom of your screen. But with no further ado, I'll invite Wolfgang Kumberg to please introduce our fantastic panelists and the session for the day.
Thank you very much, Laura, and thank you everyone for joining us today. As Laura said, my name is Wolfgang Kumberg. I spent nearly 30 years on the investor side as in-house counsel to several multinational companies. And in that time, I was involved in numerous disputes with states and came out of it believing that there must be a better way to deal with investor-state conflicts. So now I'm a full-time dispute resolver acting as a mediator and arbitrator. So looking at the world that we have today, what will the trend be for globalization and international investment in the post-COVID-19 world? And what will the impact be on ISDS? Will the current pushback on globalization and increasing criticism of ISDS arbitration provide a catalyst for the development of investor-state mediation? With the signing of the Singapore Convention on Mediation in Singapore in August 2019, mediation has been given new credibility by states themselves as an international process for the resolution of disputes. To understand that in the context of investor-state disputes, one must first look at what's been happening by the way of encouraging the use of mediation in this forum. 5 years ago, we started our efforts in the critical energy space by assisting the Energy Charter Treaty ECT Secretariat look at how mediation could be introduced to its rules. Alejandro Carbello-Leda will review this critical effort in more detail during his session. In addition to the ECT, we've also been working with the International Mediation Institute of The Hague, IMI, to develop mediator competency criteria for IS mediations. Mark Appel will discuss this further during his session. The International Center for Settlement of Investment Disputes, ICSID, the ECT, and the Center for Effective Dispute Resolution, CEDAR, have worked together to develop IS mediation awareness programs and training for mediators and states. It was recognized that without this training, the knowledge required by states and mediators to mediate would not exist. James South will discuss this in more detail during his session. Key to the acceptance of mediation in these disputes is the fact that ICSID, the organization through which most of these disputes are actually heard, has given its full support to the development effort. This culminated with ICSID proposing its own IS mediation rules. This has given the initiative credibility with both investors, their counsel, and states. Frau Konieczka will be discussing this during her session in more detail. In fact, there have already been several important investor-state disputes where mediation has been used. The most recent reported case was that of the Dominican Republic and Odebrecht that was mediated this January by well-known international mediator, Ms. Mercedes Tarazon. The matter was mediated under the ICC mediation rules and led to a settlement agreement between the parties. Malik Dallin will explore how IS mediation will potentially be used in China's Belt and Road Initiative. UNCITRAL, after its successful conclusion of the work leading to the Singapore Convention, is through its working group 3 now reviewing ISDS reform. An important element of that review is also looking at how mediation fits into the process. So with that, I would like to turn to the first speaker on our program, Judith Kneiper, who is a legal officer at UNCITRAL and a key individual involved in both working groups 2 and now 3. Judith?
Yes, thank you very much indeed. And I'm terribly sorry that our secretary, Anna Joubin-Brett, is not able to join today. This is because we are having the last day of our commission session and we are facing a number of unforeseen challenges which resulted in my trying to replace her. So the topic I was given is speaking of the UNCITRAL mediation framework. So the first instrument I have to mention is, of course, the Singapore Convention that was already mentioned by Wolf, the Singapore Convention, also called the official title United Nations Convention on International Settlements, Agreements Resulting from Mediation. And that is in a uniform and efficient framework for the enforcement of international settlement agreements resulting from mediation, and also for allowing parties to invoke such agreements. It's akin to the framework of that the Convention on the recognition and enforcement of foreign arbitral awards, the newer convention, provides for arbitral awards. So this is the one of the key instruments we have. And just 10 minutes before the panel started, I got the information that Belarus ratified the convention, which means that today we have 52 signatories, out of which 5 already did ratify, which means that on the 12th of September 2020, the convention will enter into force. We have as well the UNCITRAL model law on international commercial mediation and international settlement agreements resulting from mediation. I'm not reading the whole title because the whole title of the law is as long as the law itself, so I think that will do. The model law on mediation is providing an overview of the whole procedure of the mediation procedure, and we took as a basis the model law on commercial conciliation from 2002 and updated it by what is also regulated in the Singapore Convention, which is the framework on enforcement. Then we have one additional text that was already drafted in 1980, which are the conciliation rules. And you may note that I'm using the term conciliation and mediation. This is because in the UNCITRAL context, we are using the term conciliation, mediation interchangeably. But the key term nowadays, since we have the Singapore Convention, is mediation. In 1980, it was conciliation, and that's why the rules are still called conciliation rules. These rules are being updated now. They should have been discussed in the frame of the commission session that just takes place, but that was not possible because we are unable to really work substantively on our texts in a virtual setting. And this is because we face a number of challenges. We are normally negotiating and drafting our instruments in the 6 languages, inviting all United Nations member states. So we do send out 193 invitations. And all of this is difficult to really do virtually because of different time zones, because of very limited time virtually, because of difficult technical issues we face, with the main question being always, do you hear me? So this results in our the lack of the discussions on the conciliation rules, mediation rules that were to be adopted at this commission session. Likewise, we prepared for this commission session notes on the mediation procedure. These notes and the conciliation mediation rules will hopefully be then adopted at a later stage when maybe we are able to work to again meet in person, or when we find ways of negotiating virtually or in a hybrid way, or we don't know yet. Regarding working group 3, as mentioned by Wolf, which is our working group dealing with ISDS reform, the working group 3 has a 3-step mandate. The first step was to identify all relevant issues. The second step was to see if these issues warrant reform. And the third step, and this is where we are now, is to develop solutions. And in that context, it's interesting that mediation was mentioned as a core issue for many states. So many states have an interest of promoting, of fostering, of trying to find ways to improve the access to mediation in the context of ISDS. So I think that's a development we will have to observe. There's nothing more I could report on that. Except that the Secretariat already prepared a paper for discussion that, which is working paper 190, which you can find on our website under working group 3. And there you also find a webinar that we did on mediation, where we tried to explore how we might continue the discussion in the working group and how we might bring the topic forward, but nothing more. So I do hope that I'm able to come back to the group and to all of you with more concrete results once we have really had negotiations in the working group and where we are hopefully able to report some tangible results, how to promote mediation further.
Thank you very much, Judith. That was extremely helpful. One of the questions that's already come up and that we often get is, in what fashion does the Singapore Convention actually apply to ISDS? Does it simply promote ISDS mediation, or would it actually be applicable or enforceable against a state?
Yes, so there is some discussion, and that the issue of the discussion is, the core of the discussion is that we use the term commercial, but in the UNCITRAL context, the term commercial is used in a very broad way. So if you look in the footnote 1 of our model law on arbitration, investment is defined as being part of the commercial area. So we have a very broad understanding of the term commercial, and we think, and many states report back to us, that one argument for them to sign up to the Singapore Convention is because they want to promote ISDS in investor-state. We have a reservation in the convention, which is the reservation 1.8, which you might call the ISDS exclusion reservation, if you don't want me to read the whole paragraph now. And this is this reservation might be raised by some states. This is what we need to see. From the 5 states we have so far, 2 raised that that reservation, but we heard from many other states that are in the process of ratifying that they do not wish to raise that reservation. So from that perspective, yes, indeed, I do think that it will be used very much in the area of ISDS.
Right, okay, thank you very much, Judith. Just very quickly, one other question that's come up is, you said that conciliation and mediation are synonymous in the context of what you were discussing. Obviously, in other contexts, it sometimes is different, and maybe Frauke could even talk to that in respect to ICSID when she talks about the mediation rules because there are conciliation rules. So just we'll leave that. I think somebody had raised that question, but it's a good question to ask. But from your perspective, looking at it from the UNCITRAL perspective at the moment, you are saying that in that context, it's synonymous in mediation conciliation.
From the UNCITRAL perspective, it was used interchangeably since the very beginning. So if you take a look in for instance, in the model law on commercial conciliation, the definition is to have a third party neutral that is helping parties to find a good solution to their conflict, independently of the term you may call it, and then we name in the law, you may call it mediation, conciliation, or any other term. We are not sticking to the term to have to apply the instruments.
Right, right. Okay, very good, Judith. Thank you so much. Very much appreciated. Mark Appel, who is an international arbitrator and mediator, spent many years in the ADR world. He headed the IMI task force on investor-state mediator competency criteria. So Mark is somebody who's very familiar with this area. And Mark, if I could now turn it over to you.
Sure. Thanks, Wolf, for the kind introduction. Most of our listeners are probably familiar with the mission of the International Mediation Institute, which of course is quality assurance in mediation and access to justice, two very important issues. And quality assurance assists use of the process and acceptance of the process. And so not unusual, I think, that the IMI turned its attention to investor-state mediation on or about 2014 with the creation of the IMI Investor-State Mediation Task Force. The original chairs, Judith, were your boss. You know, Anna Zubin-Brett was one of the co-chairs, along with Bart Legum, who, of course, for years worked with the government in the United States. So there was a significant investor-state expertise right from the top and right from the beginning. There were 29 experts who were convened, and that's, again, an IMI role. Convene stakeholders in the community, stakeholders in IMI, in mediation and in investor-state. These were mediators, arbitrators, academics, representatives of states, representatives of investor organizations. So, and the idea was to create a document that would assist states and investors in the selection process and finding a suitable and competent mediator. That was the goal. And so they began their work. They began in 2014, as I said, and almost really did the great amount of the legwork. I took over the task force, or became chair, in 2016, and my responsibility really at that point was to just bring it to a finality. Finish the process and publish the criteria, and that's what we did within several months. So September 2016, you can review the criteria on the IMI website. But there are 5, and one sort of omnibus catch-all criteria. I think it's labeled other. None of the criteria would surprise you, but hopefully they will be helpful. So for instance, first, familiarity with investor-state dispute settlement issues. We're talking about a complex process. Public international law, treaties, commercial law, expectations, layers of governmental agencies, sometimes multi-jurisdictional issues. So an understanding of what's going on procedurally and substantively in ISDS is sort of a prerequisite. Secondly, mediation expertise. Mediation is not litigation, and it's not arbitration. We're talking about a helper, not a decider. And having experience and expertise in the process is both appropriate and I think necessary. What it does suggest in that particular criteria is that experience involving public entities, states, is helpful, and for all kinds of good reasons, including understanding ratification issues, sovereignty, these kinds of things that will come up. Third is understanding that people negotiate differently, and so understanding a wide range of negotiation and mediation techniques. The best of mediators are built that way. You know, they're flexible. It's what the right process at the right time. I recall a phrase from one of my colleagues asked whether she was facilitative or evaluative, and she said yes. You know, I facilitate in the morning and I evaluate in the afternoon. So you use what you need to get through the process. Fourth was an understanding of the arbitration process, and particularly an understanding of the ISDS arbitration process. We have Frauke who's going to talk to on that subject, and of course Judith and Alejandro. So we have the major institutions who were all engaged and have been engaged actively with the task force since its beginning with us. But understanding that process is important because you're operating in the shadow. You know, you're operating in the shadow or in anticipation of an investor-state arbitration, perhaps post-arbitration litigation, current litigation. So understanding what goes on in that process is important for lots of reasons. And then finally, cross-cultural expertise, cross-cultural understanding. As a institutional representative many years ago and looking to select the right mediator or arbitrator, we used to ask ourselves, you know, you have the skills, but are you international? Are you truly international? And it's not everyone that can walk in different worlds and talk in different worlds and listen in different worlds, and that's what you're looking for, someone who can, you know, bridge those sort of cultural, disparate cultural expectations. So those were the five. You can read them in much more detail on the website, as well as an article multiple articles discussing. The sixth was a sort of catch-all, but the one that I think is great, and prescient really in 2016, was the need to understand how to facilitate communications online. So we're talking about the Zoom world we're in right now. That's 2016, so somebody was thinking ahead. Since publication of the criteria, the task force has gone on to a number of other activities, all meant to provide practical advice, tools for parties to use in approaching this process and using it effectively. So there are multiple articles published by various members of the task force on the IMI website. There's been lots of collaborative programs with UNCITRAL, with ICSID, with the Energy Charter Organization and others. Collaborative development of a series of tools, which Alejandro will talk about in his, I'm sure, remarks. Advice and assistance to UNCITRAL and ICSID on rules, and UNCITRAL on the notes that were referenced by Judith. And this work will continue. Shanti Abraham has recently taken on the chair of the task force. She wrote in a wonderful note to members of the task force, recognizing that our world has changed in the wake of COVID, and that this will provide an opportunity for people to look more carefully at mediation, at mediated solutions. And so I think there's a bright future for the process there. I think that's it for me. Thanks, Wolf.
Thank you, Mark. It might be interesting just to hear from you, given the competency criteria, who's likely serve as a mediator in these cases?
Yeah, it's a great question, and you know, the first mediator I think I've come across in the literature was Robert Strauss of Investor-State Matters, who was a diplomat and a confidant of governmental leaders and of corporations, and more recently you mentioned our good friend in Barcelona. So you know. Mercedes. So they are a mediator, arbitrator, both international background. What's important, and I think it is mentioned in the criteria, is that even though they're meant to be looked at cumulatively, there's really a give and take. So what parties need to do is look at the issues in the particular case and then find someone suitable under the circumstances that fits the right, you know, hits the right notes for that particular matter.
Right. Do you think, Mark, that co-mediation will be used in
It's a good point, and it is referenced in the criteria and in multiple documents, of course, now in the field. In a particular circumstance where you might have an environmental issue locally, or a siting issue, or an employment issue, or a community-based issue, you might well see the involvement of NGOs, community organizations, and it might be appropriate in that particular circumstance to have someone who is a mediator locally from the community working with someone who is perhaps has more of a background in either public international law, international arbitration and mediation. So I think from the beginning we've contemplated co-mediation may well have a place in ISDS mediation.
Right. Well, thank you very much, Mark. That was very interesting. Now I'm going to turn it over to Alejandro Carbello Leda. He is the General Counsel for the ECT. And if I could just say, and Mark's already commented on this, I mean, the ECT has done an amazing job over the last 5 or 6 years in pushing the effort to introduce mediation to ISDS. That's an organization, of course, that is energy focused, but it has, I believe, 54 member states. Alejandro can correct me, and it has a very broad reach across the globe. So it's been able to play a key role. And so I'm going to turn it over to Alejandro to speak a little bit about the efforts the ECT has been making. Alejandro?
Yeah, thanks, Wolf. So just to summarize in around 5 minutes, some kind of 5 years of work on this with all of you guys, very intense and very nice work. Going back to 2015, the idea was, well, there seems to be some interest in mediation, but it was not clear to what extent and what were the problems with it. So we ran a couple of roundtables. On the one side, companies, energy companies, and the other side, government officials dealing with investment or with disputes. And we asked in a very informal way, how do you solve problems? Or how would you like to solve problems? And what are the concerns? What are your problems you see there? And we found out that there was a general position in favor of early resolution and in a mutual way of the disputes before it can go really to arbitration or something more complex. Now, there were a couple of problems there, of course. The first one was lack of awareness. What is mediation really? How does it work, when, etc. And the second one is, yeah, I know something about that, but actually, when I want to sit down and implement it, there are some problems there. It's not very practical. Therefore, the first thing we sat down with ICSID, SEC, ICC, PCA, UNCITRAL, CIDR, IMI. So we try to bring people who had experience in mediation, in disputes, and say, well, how we can produce a guide that will simply explain what is investment mediation, when can you use it, how do you prepare for it, which is an important key. So you sit down, what is the tick list of things to consider, and what are the elements you can consider and say, wow, in this case, yeah, it makes sense to think about mediation. Why not? Simple idea is just to give an explanation what it is, when can be used, and how. At in addition to that one, the UNCITRAL conference, which was mentioned by Wolf, has over 50 members, including the European Union and several countries in the whole Eurasian region until Japan, but now we include also Jordan and other countries. First, encourage the use of investment mediation at any stage of the dispute, and that's key, at any point in time. Second thing, welcome the willingness to facilitate enforcement of settlement agreements. And this is 2016, and it was the first step towards the very useful instrument that will come later, which is the UNCITRAL Convention mentioned before, that will facilitate enforcement and therefore give confidence that whatever you agree will actually take place later. After that, we thought, well, maybe it's important to keep raising awareness. So we had several trainings and seminars with government officials to try to have some short simulations, what is mediation, how it really happens, what's behind the scenes. And furthermore, of course, reaching to who is going to sit there, who is going to be the mediator. There are some concerns about international arbitrators, will be the same for the mediators, how we make sure that they are up to the stakes and they can really deliver. So for that, again, we join efforts with ICSID, IMI, and CDR, and we try to facilitate that possibility with several trainings. We had in Washington, Paris, Hong Kong. We keep moving around so that we have a global outreach. And at the same time, in those training mediators, we also bring government officials. So at the same time, they see how things are and what are their main concerns. So that's raising awareness. If people don't know what it is, they will never consider it. But a different thing is, okay, now I know what it is. I want to buy it. Now, how I make sure that it's going to work, really. And we had additional surveys with government officials and analysis of domestic legislation. And we try to find out, okay, so what is the main practical problems there? People who actually are dealing with investment disputes every day, and what are the main concerns? And we found two main important things. The first one is that there was a lack of a clear domestic legal framework. So many people say, okay, yes, I know about this. I want to use it. I want to tell my, whoever minister or president, whoever takes decision, but actually, I don't know. I don't know who will take the decision on this. Actually, I don't know if I will be allowed because the Constitution is not very clear on that. I don't know even if I can put this on the table, who will give the final okay. I don't know if someone will say later, there's something strange going on between this government official and the company. Maybe it's so fraud, corruption, we don't know. And at the same time, there were very practical issues like, well, if I go Geneva, I go wherever and sit down to negotiate and mediate, who will cover the cost? At the beginning, who will give me the funds to go there and to get the lawyer, etc., etc. So very practical issues. Second one was that there was also a lack of a very early independent assessment. That means what happened in many cases, the states received the complaint, it passes from one desk to another one until they found who will take care of it. And in some cases, they just rush into the arbitration. So there is no clear, 5 minutes, sit down and say, wow, this one, is it worth arbitration? Should we consider mediation? Should we sit down and negotiate with the investor? Is there a problem there that we may face? So this clear independent assessment before finally taking consideration where to go. Therefore, based on all these concerns, we work again with several government officials, international organizations, and we came with a model instrument. And as the name, again, taken from the experience of UNCITRAL, we call it model because it can be whatever the state wants. It can be a law, it can be a decree, it can be whatever you call it. But the idea is that it's a piece of domestic legislation that will give the certainty to the government officials and to the foreign investors about who will coordinate, manage the dealing with investment disputes and investment problems. And to make sure that that is particularly cover the possibility of mediation and conciliation, and that this is also taken into account when assessing what are the different options, and to know who actually is going to be in charge of and dealing with all those things. This particular thing, we provide technical advice to several states already, and the idea is that each country can decide whether, how it will be more useful for them and can they implement to their particular needs and circumstances. And we keep working on that one, and it's always been a pleasure to work with all of you guys and to keep advancing and promoting investment mediation. Thanks.
Yeah, thank you, Alejandro. Again, the ECT has done so much in this area. I mean, the model instrument is key, I think, because that puts a framework within a state as to how they're going to deal with these disputes. Just how does it specifically address mediation, the model instrument?
So it tries to deal with the investment issue, this investment dispute in general, and it in particular has several references to mediation. The first thing is when we define what is considered as an international dispute mechanism, settlement, we consider that mediation and conciliation is one of the options, to have it very clear there. There also, when dealing with who coordinates with the defense of the state, vision of the state, it also addresses the issue of mediation and conciliation. And more important and more in particular, we try to make sure that when whoever is going to be in charge is trying to assess the problem and trying to elaborate what's going to be the strategy to deal with the dispute, will take into account the possibility of mediation and conciliation, and to see, well, it may work, it may not work, and at least to make sure that it is there. And there are additional articles that they are dealing only with mediation and conciliation, and has issues on how to appoint a lawyer or a supporting advisor, and who will give final support or okay to any settlement agreement. So all these particularities, which at the end of the day is what sometimes have raised concerns of the government officials that they are aware of, but they have some particular needs or concerns.
Right. Okay. Thank you very much, Alejandro. A lot to discuss there. I'd now like to turn to ICSID itself, and Frauke Nitschke, who is a team leader and legal counsel at ICSID. But as I already said earlier, I mean, ICSID has also been really fundamental to the growth of the interest in mediation, and the fact that it is now looking at its own mediation rules, I think speaks a lot for it. And Frauke herself, who's been really a driving force at ICSID for this effort, and one of the earlier proponents of mediation in investor-state disputes. Frauke, if I could turn it over to you.
Sure, well, thank you. Thank you for IMI and CME to organize this panel and bring together, as you have heard already, a group of very energetic investment mediation practitioners who came up with a number of ideas over the years. So I want to start out with a bit of background. How did ICSID get involved? Wolf mentioned that. Look a little bit at the mediation rules and sort of what's the outlook. A number of things you've already heard about. How did we come to propose in 2018 to our 155 ICSID members the idea of adopting a new framework of specifically for investor-state mediation? And so the background is that over the last decade, we've seen policy decisions reflected in international investment agreements to call on mediation alongside conciliation. And here, this is the question that came up in the chat. Can the terms be used interchangeably? And we've seen from a Singapore Convention side, where it is about enforcement and reaching a broad scope, that is a broad approach. When you look at it from ICSID, we already have conciliation proceedings enshrined in the convention, and we are looking now at adding another process that has different features and a different scope, and we'll look at that maybe in a minute. So we have the policy decisions by the states. Then we have what Alejandro already described, the really active participation of over 1/3 of ICSID's member states engaged in the development and adoption of the 2016 investment mediation guide. So not only do you have it on the policy level, but you have it on the practical level as well. The international community as a whole worked, as Judith described to us, to adopt and develop the Singapore Convention, and we've seen the uptake with Belarus signing on this morning. There was also a question in the chat on the Singapore Convention that Judith touched upon. So you see from the negotiation history that there was an intent not to exclude investor-state disputes from the application of the convention. And as Judith explained, there are a number of states that actually specifically are interested in that piece. And as we will see, the ICSID rules allow to meet the formal criteria for the Singapore Convention. So should anybody wish to avail themselves of the Singapore Convention for an enforcement of an investor-state mediated settlement, that would work under the ICSID rules. Then what do we have? What were other indicators for mediation? And that is what got me first started on it, is if you look at the settlement statistics in investment arbitration, and I work on statistics at ICSID, and you see that you have so many cases that actually settle. So it is stable over the years that about 40% of arbitrations end in a settlement agreement and are discontinued, so no tribunal decision is required. And I was thinking more from a dispute resolution theory perspective, if that is your outcome, there might perhaps be benefit of looking at a different process to offer to the parties to choose from, should they find that beneficial. And that is also, again, where Alejandro's work came in on the investment mediation guide and the model instrument to allow the state to set up the structure and the background to engage. And engagement is really also the last point I want to raise in this context. In our amendment process, proposing the mediation rules, the feedback we've received from states is very encouraging for the future. We have states really engaged. We had a long discussion when I presented the mediation rules during our state consultation in person here in Washington in November. And that discussion touched upon how would it work? How would it look like? Could we combine it with arbitration? How would a consent look like for investment agreements? So you see, there are many indicators that suggest that we will see more of that in the future. Now, turning to the rules themselves, I mentioned already the scope is different. So what we did in the proposed rules is to broaden access to state entities to mediation in investment disputes. So many of the limitations that you have in ICSID convention proceedings or additional facility proceedings do not apply in the context of mediation. So that's one thing. The other thing that we talked a little bit about is the difference between mediation and conciliations beside the scope. We see this also here, that in the conciliation framework, you have 3-member conciliation commissions, and the members are appointed similar to in the arbitration community or in the arbitration rules, that each party appoints one, and then there's agreement on the president. As Mark already pointed out, co-mediation and a sole mediator, that is reflected in the ICSID rules. And either the mediator or the co-mediator are appointed by agreement. So here you have another difference that I want to mention. Then what is specific, also different from the other, specific to mediation and different from the other rules that we have, and that is that mediation is entirely voluntary. So parties do not only need to consent to engage in the mediation, but there is something that I would call an ongoing consent. So a party may unilaterally withdraw from the process at any time to reflect precisely that nature of mediation. Now, the other difference that I'd like to point out is the institution, the commencement of the proceedings. This is what we included in the rules because we were asked by states if we could facilitate that point, especially perhaps in the context of those states that, as Alejandro described, do not have a domestic framework where it's clear that the state may engage in the mediation. And that is, should a party wish to file a request for mediation, we offer in the mediation rules the possibility that that request includes an offer to mediate that ICSID would then transmit to the other party, inviting that party to state whether it accepts or rejects that offer, so that we have the facilitation aspect in that at the beginning of the process. So if we then look at the rules In terms of process, we came across it earlier in our discussion about different styles of mediation, and that's where we have built a flexible framework that will allow the parties to decide what kind of mediation style is most suitable in my context. So that was the goal, that we really create a global framework for disputing parties. What is the outlook here? We're working towards adoption of the mediation rules, hopefully still in 2020 by our member states. We talked about our capacity building and how important it is capacity building, not only on the side of the mediators, that you develop a cadre of investor-state mediators with the skill set and the background and context, but also the government officials. And James will talk to that. There we have developed courses for government specifically, and now that we are all in the Zoom mode, I think it will also be easier to reach different countries and governments in other parts of the world. Finally, working on dissemination of information, I've mentioned our webinar that we had last month on mediation. We published newsletters, information on our website to really keep the conversation going and help educate about mediation and the process. And with that, thank you.
Thank you very much, Frauke. Just a very quick question. At what stage of the ISDS process should mediation be attempted? Is there some concept on that?
Yeah, that's a good question. So let me take it a step back. When you are within the ISDS community and primarily arbitration practitioners, mediation often comes up in the context of the so-called cooling off period, right? That is after the notice of intent to file an arbitration is filed, and then before at ICSID, for example, it is registered. That within that period, amicable settlement period, you could consider mediation. And that's certainly one option, to include mediation there. And that's what you see in multi-tier clauses, for example, that there's a multiple step. I think what is really important is to broaden that view for everyone, to look at mediation as a tool and as a possible standalone process, which you see, for example, in the EU FTAs, that you look at mediation as its own opportunity. You could use that early on when the dispute has just crystallized. You could also consider doing that alongside an arbitration, that you suspend the arbitration perhaps and mediate parts of that. And so that is what I think is important for us, to look at mediation as a process tool that can be combined or a standalone in different ways.
Right. Okay. Well, that's an interesting perspective. Thank you, Frauke. Turning now to James South, who's the Managing Director of CEDAR. CEDAR has been very much involved in this right from the outset, particularly with respect to mediation awareness and mediator training. So James, if I could turn it over to you.
Yeah, thanks, Wolf. I'd like to take a sort of a broader perspective, because when I came into this with Alejandro and many of the people on this call in 2015, I'm a bog standard commercial mediator with some international experience. So this world of investor-state disputes was new to me. And I remember going to a conference in Miami with a mix of arbitrators and mediators, and started talking about this as I became aware of it. And almost all the arbitrators said to me, there's no way this can work. And that was at the beginning of the journey in 2015. And what is impressive, I think, is in 5 years, which is quite a short time frame for anyone who's worked in mediation development, there's been a real sea change in perspectives, I think. There are still the arbitrators who say this can't work, I'm sure, but there are many who understand that there's a need for a change and reform of the way the system works, and that's where the UNCITRAL work comes in, and the ICSID work. But also, I think it's because there's been a real shift in awareness and a sense from states and investors and institutions that this is really a possibility. So a couple of things occurred to me in terms of what was really required for mediation to take off in any sector, and applying that from our experience in other areas into the investor-state area. I mean, you do need clear competencies about what makes an effective mediator, and that's why the IMI work initially was so fundamental to establish that. And I'm not going to talk to that, but the work that Mark and his predecessors and the task force did were really crucial in setting that standards. But that's just the first step. So from there, you really need to begin to develop a cadre of competent mediators. So the training is necessary for mediators. So again, that's the work we did with ICSID and ECT and IMI to develop training, picking up the competencies and developing a training program that, you know, picked out the areas of process design, co-mediation, intercultural competency, process considerations, you know, how you manage confidentiality versus transparency requirements, for example, and other things. And I think Mark is completely right. And I see there's a question in the chat. Mediators, I think, going forward are going to have to also be competent in this area in IS disputes, be competent dealing with technology. I just can't see how that's not going to be necessary. And again, interestingly, the IMI have just come out with online mediator certification. So these things are all moving in the same direction and coming together. So I think, you know, we're beginning to see a development of a cadre of mediators. That needs to increase, that we need better diversity across the globe. We need to work on diversity in terms of gender, geographic spread, ethnicity, race, etc., which I think is important. And because this is forming new, we have a chance to inbuild diversity as part of this initiative. Clearly, the next thing you need to have is all the stakeholders on board, and that's about awareness raising. And again, I think what's been particularly marked from my experience is the desire and the hunger for states to look at the possibility of this. And Judith mentioned it, as has Alejandro and others. And what's always stopped the states is, I think, a lack of understanding about how mediation works. Then you need to get them to understand how their role is and how it fits into national legislations, as Alejandro mentioned. And then key, I think, is addressing the obstacles and the blocks, because there's always reasons why you can't do it, or we can't get authority, et cetera, but there are always ways around those. And I think what we've done over the years with the programs we've done for states, and we continue to do for states, is to help them address those obstacles in a way which is specific often to their own state. And, you know, we've had a lot of states officials at our trainings, and then they've gone back to their jurisdictions and asked us for more input, specifically to their state. So I think that's really crucial. The third thing, which is really, third or fourth thing, which is really crucial, is to have, I think, fundamental systemic reform. So if I take an example in the UK, mediation didn't take off in the UK and really until the civil procedure reforms, the Wolf reforms, which enabled mediation to take place within the civil courts. And I think you see the same thing happening here in the investor-state world. I mean, you've got the IBA rules initially. You now have ICSID rules. Clearly, all the work that UNCITRAL are now doing at you know, clear reform and change of direction in relation to ISDS is really crucial to credibility and providing the framework to allow the mediation process to operate within IS disputes. So I think we're beginning to see that fourth area crucially beginning to take hold, as well as the Singapore Convention as well. And I think then the last thing that you need is you need then mediations to actually take place. And then the credibility to begin to be shown practically, because it's all very well for us to talk about it in the abstract, but you need it to be done in reality. And as Will highlighted, there is the early green shoots of it beginning to happen with some cases, and I'm aware of a number of states who are talking to us about the possibility of mediation in IS cases, and I know it's happening in other areas as well. So I think that's probably all I wanted to say, is that it's sort of in terms of the journey and trajectory, I think it is very positive, and actually in quite a short period of time for mediation, there's been a lot of things happening to put the building blocks in place for mediation to actually take place and flourish in IS disputes.
Thanks, James. We've had a number of interesting questions come in, and I know you're very much involved in the process building aspects of how these types of mediations would actually be organized. And one question was even going beyond co-mediation, sort of team mediation, so you actually have a group of people that are involved actually as the mediators. I mean, do you see that as a possibility?
Yeah, absolutely. I mean, I think, process design is a key phase of any ISDS process, mediation process. And it may be that you have a team of process design experts who may or may not carry on to do the substantive mediation itself. And in that way, you might have process design experts as part of the team, some carrying on with a substantive mediator, some then backing out. So I think the team approach, probably given the complexity and probably the length of some of these processes, because they'll probably be broken down into chunks of time rather than being done in one space of time, I think will be an absolutely effective way to go, coupled with, I think, the online techniques.
Yeah, very good. Thanks, James. Well, we're starting to run out of time, and I want to make sure that we get now to Malik Dalan, who has been involved in international ADR capacity building for many years in many different regions of the world. His thought leadership in this area is critical. He's also involved in energy law at Queen Mary University in London. And I'd really like Malik to talk to the Belt and Road initiative and how mediation can be utilized in that initiative. Malik?
Thank you so much for this very interesting and quite stimulating discussion about a topic which I find absolutely important theoretically and practically for international law. And I always find it interesting and fortuitous that our discussion about ISDS is centering around Singapore. Reminds me all the way how the Santa Catrina case happened with Hugo Grotius in 1603. So I think the topic of the Belt and Road Initiative is very important, and in the intersection with how we view Chinese law or China's emerging trade power versus the BRI as the largest, I guess, transnational program for infrastructure investment in the world today is especially important, because not only does it involve China, but involves work carried out under the rubric of this initiative, which is expected to amount to over, the averages is from $3 to $7 trillion by 2030, and is meant to take place in some 60 to 100 countries, which obviously leads us to the question of how these projects and the disputes that may arise with works carried out under the BRI will be settled, and whether a multilateral regime will arise to affect those settlements as an alternative to what we've been all used to in terms of ISDS arbitrations, or framing things within the context of a Belt and Road, a bilateral investment treaty. So in my view, there are fundamental challenges that came about with, especially after COVID-19. But to keep things in perspective, we do have three challenges in the rule of law construction of the Belt and Road Initiative. One being that it lacks a multilateral framework. So it's not like we have a GATT agreement like the WTO. Secondly, we don't have a secretariat, an institutional form where you can go to sort of discuss or negotiate agreements or disputes. And thirdly is the point of not having a dispute resolution forum or convener per se. So that leads us to really focus more heavily on the importance of ISDS mediation, because the Belt and Road Initiative fundamentally is constructed on bilateral investment treaties. I think the added problem, which we need to very quickly address, is a problem in understanding, a deeper understanding of what is developing in terms of cultural norms in China. I think we tend to dismiss those very quickly in the West. Not that I'm defending something either way, but in the end of the day, if we again go back to the Grotius example, those are all based on international trade and investment interests, which leads to another bigger important that I face personally, is the cultural and the language barrier. I don't want this to be underestimated at all. It's a serious problem. I'm grateful that we have Professor Joel Lee, who's been one of those earlier individuals that identified the cultural element that comes in terms of sort of, he talked about mediation from an Asian perspective. And I don't think we've fully wrapped our head around that. And I think this is a problem sort of going the other way. It's also a problem when we think about how countries that benefit or are participating state in the Belt and Road are challenged when there is, or challenge or indeed can benefit as an opportunity from these trade agreements or bilateral investment treaties that arise out of China. So this is all to say that it is time for us to think in the essential development or the creation of not just ISDS arbitration, which is very easily confused in a Chinese context with mediation, with conciliation, with whatever it is you want to call it, that we may have an opportunity to respond to the area of challenges that may come up in terms of the BRI projects. And I think that there is an opportunity to sort of move beyond investor-state or trade disputes that are based on arbitration. What I would say is that we've seen signals, and I think it's important for us to think about these signals. One of them has been, so China has sort of framed these ideas on a legal, perhaps a value, an instrument, which is called harmony. To a Western legal mind, this doesn't mean much, but it's taken very seriously in a Chinese context. I haven't thought through or haven't found solutions how we can reconcile those points. But as you can appreciate, for us as mediators, if the idea is not to reach a point of conflict, then this presents itself as an opportunity, which needs to be captured by China specifically. So we have seen indications, for example, by the People's Supreme Court, where we had, or the Supreme People's Court, where they issued the opinions of the Supreme People's call on furthering or further deepening the reform of diversified dispute resolution mechanisms of the People's Court, and the provisions of the SPC on invited mediation by the People's Courts. You also saw, obviously, which is more important, is the proactive role of China in the Singapore Convention, which we've talked about extensively. I know that the Secretary General of UNCITRAL was available when the Beijing Declaration for Belt and Road Arbitration Institute was announced, and there was a little bit of a pushback to sort of say mediation. I was fortunate to be there representing James and Cedar. But again, when things are lost in language, you have a problem. They're very quickly waking up to it. There is an implementation mechanism that's happening with CTAC. There are several organizations that are being set up through the free economic zones in China, including, very impressively, these zones that are meant to also enforce Singapore Convention rules or awards. I am encouraged by that, But just as we found everywhere else in the world that it took a long time to completely and fully understand the complexity of mediation, it's going to take that time, but there is movement. I would also add that it's important that this is demonstrated for something much larger perhaps than our conversation today, which is the problem with trade wars. That there is a problem that we're seeing in supply chains. There is a problem, and that's affecting every contract that we can think about, not just projects. So I do encourage this group. I know that Alejandro and the ECT have worked in various capacities trying to help China develop its understanding. Finally, we should be encouraged that, one, this is not only a legal construction, this is a practical construction, commercial interest. Two, I've noticed that there's a huge improvement of understanding between the current generation of Chinese lawyers, including my students, and the former generation that haven't sort of completely understood these common law, money-driven damages views of how contracts or how disputes are resolved. Thank you.
Thank you so much, Malik. That's a very fascinating area, and obviously we could spend a whole session just on that. I think you've had a real flavor today from this excellent panel as to what is happening in IS mediation, and I think it's something that continues to develop, and you can see all these different initiatives that are starting to come out of it. Just maybe to say that we're continuing this discussion after a colloquium we held at Harvard last December. We're continuing this in December. December the 11th, BICL in London is actually hosting an Investor-State Mediation Forum. It will likely have to be virtual as well, but I think that's another opportunity to continue to push the IS mediation front forward. And so you're all heartily welcome to that, and you'll receive more information on that in the next few months. So with that, I'd really like to thank this panel. I'd like to thank everybody on it. You've all put so much effort and time into this whole area, and thank you very much for helping to inform others about it.
Thank you.
Thank you. Bye-bye.